Welcome to EI Legal's video on contracts. I'm Patricia Ryan, Practice Manager at EI Legal. At EI Legal, we often answer questions from our clients about written contracts of employment and whether these are a legal requirement or simply good practice. The answer is that once an offer of employment has been made, and that usually starts with a verbal offer, and it's accepted, a contract of employment is made. Committing the agreement to writing simply evidences the fact that a contract of employment has been entered into. We are often asked whether a written contract is necessary. Some employers believe that it's only necessary for senior type roles. However, we believe it's good practice to have a written contract with all employees. This does not need to be complex for simple arrangements and can be a fairly simple letter of appointment. This confirms such things as employment status, that is, permanent or casual, full-time or part-time, classification, date of commencement, hours of work, confirmation of any probationary periods, and notice of termination provisions. In addition, any particular matters of importance in the workforce can be added, such as a reference to company policy or procedures. For more senior employees, there may be other more significant matters that a contract would need to cover. These include post-employment restraints to protect the employer's legitimate business interests and clauses to protect intellectual property and confidentiality clauses. You may also wish to cover matters such as commission structure, include a statement of duties or a role description, allow for performance reviews, set out company rules on secondary employment or dress code. Where there is no written contract, a court can imply terms into the contract which may not be favourable to you as an employer. For example, in a written contract, you are likely to include a notice period. If the contract was silent or there was no written contract and no other evidence of an agreed notice term, the court will imply a term which in a long-term employment relationship in a senior role can be very lengthy. A contract, however, cannot override minimum terms that otherwise apply. For example, the National Employment Standards provide for certain leave provisions, notice provisions and redundancy. A contract cannot reduce these minimum entitlements. Having written contracts can also prompt any changes in employment terms to be documented, which will assist you if a dispute arises. For example, you might agree to flexible working arrangements with an employee for a short time. It is important that the change in employment be recorded. For the above reasons, we recommend that the employment relationship be documented in writing by either a contract or letter of appointment. If you would like more information on this topic or you have any questions, please contact us on the details provided. Thank you.